Welcome everyone to the ARAG podcast. My name's Emma Wilson and I'm an AT account manager at ARAG. Today we're going to be talking about clinical negligence claims and talking to Katherine Pearce, who is Head of Clinical Negligence and Personal Injury at Davies and Partners Solicitors. Welcome along, Katherine. It's good to have you here.
Thank you for having me. It's great to be here.
So, Katherine, how long have you worked in clinical negligence and what kind of work do you see most in that area?
Well, I'm second career solicitor. I started life previously in the NHS and then came to law later. But I've spent over 16 years working in clinical negligence, mostly handling complex cases involving neurosurgery, neurology, birth-related and baby loss claims. They're the ones that I see most on a day-to-day basis and probably where my expertise is most developed. And my personal interest in neurosurgery and neurology cases started after I had my son, who's got hydrocephalus and he's undergone multiple brain surgeries. And so I've seen firsthand the impact of how injuries in those areas can impact children and their families. And so it probably deepened my interest in wanting to make a difference in those areas.
Yeah, well, that's completely understandable. Thanks for sharing that. So today we're going to be looking at access to justice, really, and how that landscape has changed and is changing all the time. When did you start noticing the ground shifting on access to justice? And how has this changed for the average person who's now trying to bring a claim in clinical negligence?
I think the shift started really quite some time ago, probably 8-9 years ago. There was a change in terms of kind of risk assessing cases when fixed recoverable costs first came on the agenda in 2017, maybe even before that. And I think we started future-proofing our business at that point, really, and looking at what the potential values of claims were then. But I suppose that agenda's became much more advanced, and obviously with the fixed recoverable cost regime when it came into play in from October 2023 really is when there was a significant shift, and perhaps more later when the case law narrowed around who potential claimants might be, so thinking about kind of secondary victims and things like that. So yeah, I mean, for many ordinary people, I think hurdles have quietly increased, really. The industry has been saying for a long time that fixed costs in inverted commas lower value cases risk restricting solicitors' ability to meet the standards that you need to adequately investigate a claim, and can make legitimate low value but complex cases uneconomic to run is the stark reality of the position, really.
Yeah, I can see that. When people say access to justice is eroding, which is something we do hear, what do you think that actually means in real terms for claims? Does it mean fewer claims, fewer lawyers able to take the cases, or lower compensation for the claimants themselves?
I think all three of those pressures show up. Firstly, fixed costs can deter firms from taking complex but low value cases in the first instance. I think you've got the pinch of capping expert fees and expert input, and the kind of process constraints that fixed recoverable costs can put on limiting the quality of the investigation that you can carry out. And the Law Society was warning against that from 2019, and then you've got the recent decisions that have come through that have narrowed certain categories, so secondary victims again, where it's just reduced the routes to redress for families who have witnessed traumatic circumstances in those cases. So there are less types of claims is the effect. So you can see that the three things that you talked about. Fewer claims, yes, because they're less viable to take on. Fewer lawyers able to do them because you're not taking them on because they're not viable, but also because it would be compromising to the quality of investigation, and lower compensation because you're not able to value them in the same way with the same level of rigour that you would ordinarily have done. So I think all three.
Yeah, that's understandable. You touched there on secondary victims. Last year there was a Supreme Court in Paul versus the Royal Wolverhampton NHS Trust, and that addressed secondary victims' claims in clinical negligence. What have you seen has been the effect of that?
Well, I mean, the reality is that the effect has there are no secondary victim claims in practice anymore, with very, very few exceptions. So the court, with a 6-1 majority, held that those witnessing a significant injury to a person close to them can no longer bring a claim for their psychiatric injury unless what they witnessed qualifies as a accident tantamount to a that you'd see in a personal injury claim, or its immediate aftermath. And it confirmed that clinicians there's no duty of care owed to those people witnessing that. The effect is that those claims have, in all but the very rarest of cases, and we can talk about that a bit more, but they've gone, really, and there's a significant proportion of people who will suffer as a result of that because their injuries can't be compensated.
Yeah, it has actually had quite a large effect, hasn't it, on who can claim. In your experience, since that judgment last year, who has been most affected by that? Is it parents, partners, children, or wider family members that would have claimed in the past that now can't?
Well, I mean, it's the closest family, partners, parents, children who witness a significant injury or a death attributed to the earlier negligence. I mean, post the Poole case, most of those claims will fail because the event is not treated as an accident. I had significant background, particularly as I was training and working with families who have experienced baby loss, and from my perspective, this has had a really significant impact on fathers, and it just feels like an anomaly, really, and a travesty to an extent that somehow, despite being 50% of the baby's parentage, somehow or other, there is no comeback, there is no redress for fathers, and they're not owed any duty of care in relation to harm caused to their either unborn or born child who dies shortly after delivery. It certainly had a major impact. Trying to explain that to clients, to a father who has been equally impacted by the loss of their child.
Yeah.
And it's a real shame, really, that there isn't a carve out in those circumstances because of that nature of both people are parents. Why there isn't a carve out for fathers in that circumstance, and I think that's a real access to justice issue.
Yeah, I think some people were hoping that would have been the case, wasn't it? That under those circumstances it would have been a different outcome, but it hasn't been, has it?
No, and I think the Paul, Polmere and Pearce cases that were taken on appeal, they all had different facts. None of them involved those specific set of circumstances in relation to baby loss, and those firms and the insurers and the council that took those cases, that was a brave decision to make, to bring clarity to a position that had been grey for some years by the time it got to appeal. But it was a shame that carve out, it wasn't able to be kind of delineated. It would have been interesting to have seen what the court would have said, but it wasn't, and we're here, and all admiration to the parties that took those cases on appeal.
Yeah, absolutely. Do you think the Paul case, does it reduce accountability, or does it just narrow who can now claim?
It does both. It narrows who can claim, and in my view, it reduces system accountability. The accident requirement is kind of conceptually problematic, in my view, for clinical negligence, because there, in most cases, will always be a gap. It's it's not in most cases possible to witness the negligence in itself. It's the outcome as it materialises is what may well be tantamount to an accident, but the proximity point is what's been decided, and it highlights a tension between kind of legal doctrine and the real world trauma that is experienced when somebody witnesses something like that. But that's the law, and that's how it works, and that's how it develops and lives and breathes as we go through. But yeah, I mean, in a way, there is a reduced accountability, and it does narrow who can claim.
Yeah. Turning now to fixed recoverable costs, or FRC as we know it. What's the real world effect of fixed costs, in your opinion, on whether solicitors can run certain clinical negligence cases now?
I think it's pretty significant. Fixed recoverable costs make many lower value cases, which are often technically complex, economically difficult to take on, query the viability. It's interesting because the lower value cases are not intrinsically less complex, and this is specialist work, and experts are squeezed, and it just risks underprepared claims or not full investigation or representation at all. And that is the reality. And I'm sure that there are really big firms are looking at ways of trying to make these claims viable, and I really hope that there is a solution. It's much more difficult. I mean, we're a smaller firm in the compared to many, and it's really difficult to see how you can make it economically viable. I'm sure that there are cases that we will take on because it's the right thing to do, but the scope to be able to do that is significantly limited. I mean, there's an irony as well, really, that the lower value cases that are less than 25,000, they're almost more economically justifiable than those above 25 but less than 100. And there are exceptions, like there are ways of those cases coming out. It's not that all cases, less than £100,000 are not viable. It just makes it much more difficult. And when the circumstances arise that you would be making those risk-based decisions, those people are not getting access to justice because it isn't economical to investigate them. And that's the stark reality.
No, it's sad, isn't it? And we hear the label low value, don't we? In terms of low value can equate to less complex. But would you say that the label low value is somewhat misleading in clinical negligence then?
Yeah, completely. Value in this sense means damages. It's got no relevance to complexity or importance to the parties, the claimant. To me, this appears to be contradictory to the overriding objective in the civil procedure rules. That places the importance of the issues to the parties as an equal pillar to the cost. But there's a real risk that by thinking that cost is the factor, that those complex cases that need answers that will improve patient safety and learning won't be learned. And they're not less important to people who have suffered injuries.
Yeah, absolutely.
So,
yeah, I can see where you're going with that. Talking about going further from that, talking about alternatives to fixed recoverable costs, what do you think would work?
That's a big question, isn't it? I'm not sure that to opine on that is pretty significant. I mean, you can see that the theory of having fixed recoverable costs could work in less complex cases in many ways, but there would need to be uplifts for complexity, having multiple experts and causation disputes. And I know all of those things in many ways are provided for in the fixed recoverable costs regime to an extent. But at the outset of a claim, when you're looking at the risk, what you're looking at is whether you can get answers for your client in a way that is commercially viable. So really, there is the potential scope, but the costs for the fixed costs need to be realistic. They need to be relative to the complexity as opposed to the value. To go further than that, I think would be there's probably people far, far better qualified than me to be able to look at what the potential alternatives are, but this doesn't feel like it's necessarily going to achieve the aims which it sets out to do. It may well reduce costs because the cases won't run, but that has a substantial impact on access to justice.
Yeah.
And we need to be more creative. Insurers need to take risks. If we're going to take the risk, insurers need to take the risks too, I think, to look at maybe thinking of different and creative ways of supporting the funding of the cases. And I don't know what that is, and that's way beyond me. And I'm sure that ARAG will come up with the options in due course. But
we are always looking at ways to support our firms and their clients.
Indeed.
We have to as well be creative with a changing landscape, don't we? We all do.
We all do.
Another important aspect is patient safety, really. Patient safety learning, what lessons are learnt, what should redress be built to drive learning, really. How important is that?
I think it's crucial, isn't it? I mean, we can see that from the multiplicity of maternity investigations that have taken place over the last 10, 15 years. And from the current fast-track National Maternity Review, there are priorities around learning. There are priorities being placed around system changes. The implementation of them is what we're not necessarily seeing, and maybe why we keep having to have them. But without learning, the same patient safety issues will just keep on repeating. And as we've seen in the maternity space, we learn lessons, we see changes, there are recommendations, but this, we can't underestimate the pressures that the system is under and the cost of doing that. But if you're going to investigate, and if you want to learn, then there's got to be investment in that. And I don't think that investment is necessarily going to be achieved by cutting lawyer costs from a one lens. And if claims become harder to bring, we lose early warning about unsafe care. When billions are paid annually across the NHSR indemnity schemes, the smarter long-term lever is improving safety. We've been saying this for years, but it's also about openness and learning first, rather than just compressing the litigation costs.
Yeah. So we were talking earlier about complexity not always equating value. Can you expand on that, particularly in relation to baby loss cases?
Baby loss cases are a stark example at the heart of it. For me, the clients who have experienced baby loss are so impacted. It's really devastating. And low value tells you nothing. I mean, we touched on this earlier, and It tells you nothing about complexity. Baby loss cases are not low value cases. They don't necessarily fit in the fixed recoverable costs regime, but they could, and many of them will be within the threshold for fixed recoverable costs, but they are clinically intricate and they're expert heavy. The irony being that's the reason why they may well come out of the regime. And when you look at all of this, the trying to cap the number of experts, trying to limit the evidential base, it risks lowering standards in precisely these cases where the impact is so significant. And in a baby loss case, the liability issues are generally as complex as in a multi-million-pound birth injury claim.
Yeah.
But the baby dies rather than surviving with devastating injuries. The value doesn't make those liability investigations and the issues any less complex. It just makes quantifying the case slightly less so. The damages label in a baby loss case can be small, but the investigation is exacting. It's records, timelines, pathology, multidisciplinary opinion, while the importance to the family is absolutely immeasurable. Calling these cases low value is deeply misleading, and rigid fixed recoverable costs risk under-resourcing the very scrutiny these family needs, but also the lessons that need to be learnt from them. And we can learn as many lessons from the liability issues in baby loss cases as you can in birth injury cases that are going through the early notification scheme or being, having the benefit of an MNSI investigation. So there is learning to be had here, and I know some of them will potentially fall into the MNSI investigation category, but there is learning to be had, and that, as we talked about earlier as well, that impacts the patient safety landscape. And families want answers. They don't want this to happen to anyone else, and they want to know what happened to them. And without the thoroughness of that investigation, then, which is complex and can be complex, it risks undermining all of that. And I mean, for me, we talked about it earlier, or mentioned it earlier. This is where the overriding objective matters. The civil procedurals require cases to be dealt with justly and at proportionate cost, but including having regard to the importance of the case to the parties. It's not just about the money. And in baby loss litigation, that importance is at the highest. Families want answers, accountability, and learning to prevent recurrence. And fixing costs too rigidly can really undermine that principle in practice, in my view.
Yeah, I can see that. Further on, talking about children's claims, there was a recent positive Supreme Court ruling with regard to children's lost years claims. That was CCC and Sheffield Teaching Hospitals. Could you tell me a bit about that, and what does it mean for claimants now?
Well, I mean, it's a landmark decision, and huge credit to the legal team that leapfrogged it to the Supreme Court. I think the clinical negligence practitioner sector has been long hoping for this, and the Supreme Court has held that children can recover lost years for the damages, the earnings they would have made in the years of life lost because of the negligent injury, and this overturns the old rule from Croke and puts child cases in tandem with adult cases, which has long been the position in that regard. So it brings parity. The court stressed that this is the child's own loss. It isn't dependent on having future dependents, and that's important. It's a really, really positive decision.
Yeah, it absolutely is, and it's brought it into line with what was already in existence for adults who'd been harmed. Do you think, though, that this expands access to justice in a meaningful way? The judgment was only very recent, it's very early days, but what are your thoughts on that?
I think it does. I mean, access to justice isn't just about accessing legal support, is it? It's also about accessing life. And, it recognises that a child's future has real economic value, and it, as we both have said, it aligns children with adults, correcting a long criticised disparity from the claimant side. It's getting access to justice isn't just about we work in terms of quantum and compensation, but what we're really doing is putting people's lives back to what they deserve to have. We can never take them back. We can never give them 100% justice, can we? We can't ever take their injuries away. But what we can do is make things better. And it sounds a bit trite, doesn't it? But this is what this does. This is right. This is about saying children and adults have equal access to compensation in this regard for lost years, and that's an important thing.
Yeah, I agree, 100%. Obviously, we've got that, obviously with the cost reforms pulling in one direction, and then we have the law correcting unfairness in another way. Does it feel like in some ways there's a push-pull, a pulling against each other in some aspects?
Yeah, exactly that. At a time when all eyes are on clinical negligence costs, you've got Public Accounts Committee, you've got the David Locke Casey review of costs, fixed recoverable cost regime in for the £25,000 to £100,000 regime, and then CCC widens the substantive rights of children to enhance their damages rightly in parity with adults. There is a friction between this position of making of fixed costs, making complex cases uneconomic to investigate, and at the same time increasing the potential value and compensation rightly for lost years in cases involving children who have been injured. And it sits uncomfortably. They're at juxtaposition with each other, and at some point or other there will need to be some stabilisation of that, I guess.
Yeah, I agree. It's quite often the way, isn't it, in law, that these things don't always go hand in hand. They push one way, then push another way.
I don't know what film it was where they say when one door closes, another one opens, but it does feel a little bit like that at times.
Yeah, it's ever changing, isn't it? And that is how the law should be as well, really, that it is ever changing and evolving. It just doesn't always evolve in the way that we would like it to evolve, but sometimes, those things do go in claimants' favours, and that's a positive, isn't it?
Indeed.
One last question for you, Katherine. If you could change one thing tomorrow to protect access to justice for your claimants and future claimants, what would that be?
That's a big question. Well, this is a Women in Law, Women in Clinical Negligence podcast, isn't it? Yeah. So let's kind of thinking about it through that lens. Many of the clients we act for are women, mothers injured in childbirth, primary carers managing lifelong consequences of avoidable harm, people trying to, like daughters, partners, trying to piece together what went wrong in a loved one's care. And I think when the economics of bringing a case become too tight, it's these families and the women in them that feel the impact potentially first. I'm cautious of saying this, but I'm taking it from the perspective of the women in clinical negligence viewpoint. I think what worries me is that there is a kind of slow erosion that we're already seeing. Clinical negligence work is complex, it's expert heavy, it's high risk. And if the funding environment doesn't properly reflect that reality, firms will become more selective, and some really valid cases never get investigated at all.
Yeah.
And access to justice doesn't just disappear in dramatic ways. It narrows quietly at the edges. And women, particularly those already carrying caring responsibilities, often bear the brunt. And from a women in law perspective, I suppose there's another layer. It's a sustainable funding model is what allows specialist claimant teams, many of them led by women, to continue to doing this emotionally demanding and socially critical work. And if that work becomes economically unviable, the system loses not just claims, but expertise, diversity, and lived understanding. So for me, protecting access to justice means ensuring that the funding and cost framework genuinely reflects the complexity and risk of this work, but also still promotes efficiency and proportionality. Because if we're serious about fairness, accountability and patient safety, the path to justice has to be realistically open to the families who need it the most.
Oh, that was excellent summary, Katherine. Thank you so much. You really provided a clear, compassionate tour through how law and cost shape real-world access to justice today. So thanks so much for joining us.
Thank you for having me.